All right, here to help us break down all of the news about the potential indictment of a former sitting president of the United States. She's a white-collar criminal defense attorney. She's also the author of a book. I mean, this is so appropriately titled, Unprecedented, A Simple Guide to the Crimes of the Trump Campaign and Presidency. I can think of nobody better to help us break down all this legal news than Sara Azari. Sara, Mike Leon, Nick Saveri, thank you so much for hopping on the podcast with us.
Thank you guys for having me.
Yeah, I mean, Sara, when I reached out to you, I've seen you doing a bunch of TV hits across the media sphere, and I know you've been covering a murder trial and the Alex Murdaugh trial, and no murder here, but I did want to ask you about if we could get into this because there is so much about this potential indictment of a former president that as of this taping, nothing has happened. It's all been smoke, and there's no fire just yet. We do know of the events that happened back in 2016 and this hush money payment. From where you're sitting as a criminal defense attorney, the center of this case and the focal point for the Manhattan DA, what do you make of this case and where it could lead in terms of a potential indictment of a former sitting president of the United States?
Yeah, so look, I think that, well, the saying, you can indict a ham sandwich, but the bigger question is whether you can get a conviction. And that's where the defense lies. And, we're sitting here going, when is the storm coming? It was supposed to be stormy Tuesday, then it was a stormy week. And now we don't know if the storm's ever coming and what, category it is, right? But the idea here is it's really not about the fact that hush monies were paid. That's undisputed. In fact, Donald Trump was individual number one in Michael Cohen's indictment on the federal side, to which he pled, like to 8 counts. So that's what my, one of the chapters of my book talks about. No doubt he paid the hush money. The question here is that this is a booking charge. The idea that this payment was made and then it was classified falsely or booked falsely internally as attorney's fees, right? And this very much turns on whether Donald Trump knew that he paid hush money payments and knew that it was categorized internally as an attorney's fees. And so to me, it's, look, we don't know yet exactly who the witnesses have been before this grand jury, but it seems to me like Michael Cohen might be at the very, very center, the crux of this, all the testimony that the grand jury's heard in New York. And of course, Michael Cohen has credibility problems, right? He's a cooperator. He has beef with Donald Trump. He was a fixer for many years. He lost his license. He lost his life. He served prison time because of this conduct. And he also lied to the SEC. Initially, remember, he said that these were not hush money payments. But since that time, he has had a mea culpa. He went before the Congress. He testified. He came clean. He has, since that time, been very consistent about the story and the real truth. And so, look, if in every case that there's a cooperator, we defense attorneys could prevail, then I'd be winning all my cases. It's not always just because you have credibility issues with the main witness that's a strong case, or the strong case for the defense, you would prevail. The idea here is there's also checks signed by Donald Trump. There's also audio between Donald Trump and Michael Cohen that corroborates whatever Michael Cohen testified to. But ultimately, there are problems. Okay, there are problems in New York. And I know we keep saying this every time we think Donald Trump's about to get indicted and about to go down. We defense attorneys come in, and honest prosecutors also, and talk about the problems, right? The problem is, number one, the statute of limitations. In New York, there's a 5-year statute of limitations, which even is starting from the last installment on the hush money payments. 6 years has passed. So during the pandemic, former Governor Cuomo extended or told the statute of limitations to extend that time. So they might be able to overcome that hurdle. But then you have, the idea that this is a misdemeanor nothing burger, right? This booking charge. No way he would do any time on it. The maximum is 1 year. Nobody does time on it. So the question is, can they stretch this to be a Class E felony under New York law, which is still a nothing burger felony? A shoplifting of over $1,000 is a Class E felony in New York. And maximum of 4 years. Again, unlikely that he would serve any time as a result of it. I don't think it's going to impact his ability to run for president, even serve as president. It's the irony is that you can't vote if you're a felon, but you can certainly be president, right? That's just how it is in our country. So it's really not going to impact him politically, I don't think. It will impact him politically if this DA brings the charge and it falls flat. I mean, that's what Donald Trump wants, right? In every situation. Bring it. It's all a witch hunt. It's all a hoax, and here, I'll prove it to you. So that the evidentiary problem is, number one, Michael Cohen being the main witness in the case. Number two, how can they tie this to another crime to make it a Class E felony? And that other crime, you guys, would be something like bank fraud, wire fraud, money laundering, mail fraud, things that are federal crimes. And so then the appellate issue here is going to become, if he's indicted, can a state charge a Class E felony? Can New York charge Class E felony when this other crime that's related to this misdemeanor booking charge is actually a federal crime, not a state crime? So that's where it gets really hairy. And this is that if he's indicted, I think he's going to have a huge appellate issue in that regard. And then the last hurdle I see that's, fodder for the defense is he's going to come in and say, and I think I've heard him in some of his recent speeches and social media stuff, saying that advice of counsel, Michael Cohen was a licensed attorney. I was relying on him. I listened to what he told me to do. I thought this was perfectly legal. The problem is that he also needs to show that he relied in good faith. That's where he's going to have a problem, because Donald Trump, even before 2016, was very familiar with campaign laws. He was a big political contributor in New York. And these are laws that are very well known, very well established. They don't change from year to year. So it's going to be very hard for him to prove that, that in good faith, he listened to everything Michael Cohen had to tell him and didn't really have any knowledge otherwise, right? But those are really the issues I see for the defense. I mean, unless, one of the things that concerns me is this delay. Because a grand jury is supposed to be a cakewalk. And when you're going day to day, week by week, and Donald Trump has sent in his attorney to testify in lieu of himself before this grand jury, you got to wonder whether they're having some evidentiary struggles and are, scrambling to get other witnesses and other evidence in before this grand jury, before they move forward. So, if I were to read the tea leaves, is he going to get indicted? Probably. Will it stick? Probably not.
Sarah, and thank you for just summarizing at the very end, because that was the question I was always sitting with. Something that Mike and I have been seeing on social media is the lack of understanding the difference between what is the role of the grand jury here versus a jury trial. Often when we're talking about the former president and people in general, we hear these ideas about moving forward to jail or punishment, and obviously you're talking about a grand jury. There's a huge step there, obviously leading to indictment. Can you take our listeners through just that process and why that just stands in distinction to when we think of the traditional jury trial?
Right. And there's a difference between a jury trial, a jury for the purpose of trial, and a grand jury. The grand jury, many jurisdictions like New York use a grand jury as a way to establish probable cause. Is there enough to indict the person? Is there probable cause, which is a low standard, that a crime was committed and that this person committed the crime, and therefore they should stand trial? So it's a preliminary charging step. Very different than a jury trial, because at a grand jury hearing, typically the defendant is not present, cannot be present. It's a secret here. It's a secret proceeding. The defendant and his lawyer are not present. You've got the jury of 12 or more people, depending on the jurisdiction. You've got the judge, you've got the court reporter, you've got the prosecutor, and the witnesses, and that's it. The difference in New York is that under New York law, in a grand jury, the defendant has an absolute right to testify. Donald Trump was invited and he obviously declined. Instead, he sent his attorney, and his attorney, I've lost track of all the names, but starts with a C. One of his attorneys, basically, according to reporting, he blamed, Michael Cohen. He threw him under the bus. He attacked his credibility. So he's really more of an impeachment witness, right? And so I don't know if this delay in, reconvening the grand jury, moving it towards indictment, is because of maybe what he testified to, and they're now sort of crossing their T's and dotting their I's, filling in the blanks, or just in general having a better idea of the totality of their case and trying to bring in what's missing before this grand jury. And I think the $1 million question is, will this be tied to another crime to where he's indicted on a Class C felony, or will it remain as this nothing burger misdemeanor? But there is that nuance under New York law where in the grand jury proceeding, the defendant has a right to testify.
Sara, I'm so glad you said something earlier about social media, or you saw the speeches of the former president, because as a criminal defense attorney, I wanted to have you on because how hard is it for you to see your client out there posting on a social media platform? Evening local news, national news outlets are capturing that soundbite and or at least that screen image. As somebody who used to work for a news organization before and would capture that stuff and put it into a full screen graphic and get it out there. How hard is it for you from a legal perspective, if you were his defense attorney, to say, hey, stop doing that because you're giving away some of the things that I'm going to have to argue in court? And also, how much of that, in your opinion, is leaned on in these trials that the former president is facing? Because there could be a charge coming up in the Georgia case. We're going to get into that in a second. We don't know what's going to net out with the special counsel. Just take us through, if you were Donald Trump's attorney, you just lost track of how many attorneys, so have I. What would you be saying to the former president right now in terms of the social media and the visibility and everything that he's trying to get in front of with respect to all these cases?
So, I run into this issue sometimes with some of my higher profile clients. Sometimes they're Hollywood people. There's a bigger need to, try to restore their image in the court of public opinion. They think that the best person to do it is them. They don't want to wait. They're impatient. They don't want to wait for the legal process to take its course. And that lends itself to some level of unmanageability. Donald Trump, I think we can tell now. I mean, right now he gets all kinds of lawyers. Some of them are corporate lawyers. We just can't figure out how they even got involved in a criminal investigation. But there was a time where he had some of the finest lawyers in the country, and it's obvious that he's probably the world's most unmanageable client. I don't think anyone can say anything to him to convince him that he has to remain silent. And I think that to a large extent, politically, it's worked for him to run his mouth. Might not help him legally, but, somehow so far he's gone unscathed legally, and politically he's managed to use his words in a way that fuels his supporters and keeps it going. I mean, I think until that time comes, I don't think there's been any repercussion really for him, really remaining silent, which is what every defendant should do when they have exposure.
Sara, pivoting for a moment to the classified documents that the former president had in possession of at Mar-a-Lago and didn't return, obviously, to the National Archives. We've seen a recent ruling from the appeals court siding with Department of Justice about allowing them to speak directly with one of the attorneys. Just as it relates to the documents and the ability to talk to an attorney outside of client privilege, what's your assessment of what's going on as it relates to that case?
So the document case, to me, so far, is probably it's the one with the most legs, I think. And it seems to me, you've got two sets of charges here. You have the issue that the documents were highly classified, they were mishandled, they were removed, and they were retained. And then you have the obstruction of justice and the criminal contempt part of it, where, knowingly he was moving them around and then claiming that he had searched for them, there were no more documents left, etc. So the DOJ, that their burden of proof ultimately is, if he's indicted on that side, is that he intentionally retained these documents, and intent is obviously an element of almost every crime, mens rea, we call it. And so his knowledge that he had these documents and that he was knowingly refusing to turn them over to the National Archives and then to DOJ, despite multiple repeated requests, is very key here. And the fact that Corcoran, his lawyer, is now an appellate court has ordered that he is to take the stand and testify, and that the attorney-client privilege is to be pierced so that he could freely testify. It's unclear whether he's a cooperator or he's been given immunity, but attorney-client privilege is not that readily pierced. So to do that, that tells me that there's a belief by the court that there's some serious compelling evidence of crime, okay? Because the crime fraud exception is one main reason why, one of the biggest exceptions to the attorney-client privilege. And so the next layer of issues is that not only Corcoran testifies, but oh Lordy, there are tapes. And so the tapes come in, the documents come in, and that is further piercing of attorney-client privilege with respect to the documentary evidence. So you've got his testimony, and then you've got the corroborating additional documentation, including recordings. This to me is huge, that an appellate court has ordered his attorney to testify, whether by immunity or cooperation, and that the attorney-client privilege is going to be waived. In this regard, it's really telling of the strength, I think, of the case that the DOJ has. I think, look, we can expect Corcoran will be asked very tough questions like, I don't know, what did Donald Trump tell you about the document subpoena? What did he tell you, about having the documents? What did he tell you about moving the documents around? What did he tell you about searching for the documents? Did he tell you that, yeah, I know I have them, but let's just not cooperate, essentially ignore these multiple repeated requests? Did he instruct you to refuse to cooperate and turn these over? So his testimony is huge, and he's going to be asked very tough questions that typically we wouldn't have to answer because, it's privilege, except here you've got the crime fraud exception kicking in. And not only he gets to testify about them, but to the extent there's documents and communications between him and Trump and the team and Trump, and then also, obviously tapes that we know exist, those all come in as well.
Sarah, I'm so glad before you brought up about Georgia, because we had a mutual friend of ours, Ellie Honig, CNN senior legal analyst, on the show. And Ellie had mentioned a while back when he was on the program about what would keep him up at night if he was Donald Trump's defense attorney. I know obviously he was a former prosecutor, and the big one he kept focusing in on was Georgia, right? Because of the evidence, the phone call specifically, asking to find the 11,000 or so votes. What parts of that case to you kind of stand out, especially on the defense side? Like, how would you defend an indefensible phone call? The president keeps alluding to it as a perfect phone call. Obviously, we know it's not, but from a legal perspective, right? Some of the things within that phone call that could be misconstrued or very vague. Could you take us into that case, and what would that keep you up at night if you were defending the former president?
No, because I just had a recent conversation with Ellie about this. I know how he feels about Georgia. I beg to differ because I do know Drew Finling, who's Trump's attorney in that case. I've known Drew for decades. We were both very involved in the National Association of Criminal Defense Lawyers. He was the president at some point. He's my go-to person in Georgia. If I ever have to refer a state case, I call Drew first. Very, very respectable, hardworking justice warrior, and very liberal also. And he is in this for the process. And the problem and the defensibility of the Georgia case is the process, the procedure. So yes, I agree with Ellie that the call, Donald Trump calls every call perfect call. Remember Ukraine? Ukraine was a perfect call. Every call is perfect. Perfect. It's not. But he definitely, wanted the results flipped, wanted the state flipped. He said that. It was a 60+ minute conversation with Raffensperger. Clearly he was meddling. Clearly he, it was fraudulent. But defense attorneys come with context. Prosecutors take a soundbite. Prosecutors take that, 6 seconds or whatever of that 60+ minute phone call. We come in with the entirety. If you look at the transcript of the rest of that call, there's some backpedaling by Donald Trump. He's a browbeater. He says things like, you want to be accurate about the count, don't you? You want to make sure this is correct before you certify. There's those kinds of conversations which sort of dilute the very incriminating 6 or 7 second soundbite that the prosecutors are running with, right? So you've got the context that defense attorneys bring in always, and and prosecutors take things out of context. But more so, there is a 50+ page motion that Drew filed with his team that I read with, like, the totality is like 400+ pages because of the exhibits that are attached, essentially going after the DA in this case on multiple grounds, saying that this was a special grand jury, which under Georgia law only has authority in civil matters, not with respect to a criminal charge. So they're saying the statute is vague. They misinterpreted the statute, they misapplied the statute, and that this is not the appropriate mechanism by which to bring a charge. So therefore, we're asking the court to quash the entirety of all of the findings in the report of the special grand jury. So it's a motion for huge relief, which if granted, there goes that process, right? The whole grand jury process to indict him on this election fraud charge, or it's actually racketeering, multiple people involved, and that's another issue, is that Drew has gone after this DA and this DA's office for abusing the racketeering statute under Georgia law. It's sexier to say racketeering, but it's really just another conspiracy, right? But racketeering, this is huge. Racketeering has very loose evidentiary rules, and you can bring in more when it's racketeering. There's a lot of perks to that. It's the prosecution's wild card. And so Drew is saying, you know what? I don't care it's Donald Trump. And he's right. I don't know that I could defend Donald Trump personally, but we are here about the process. We fight for the process. We fight against governmental overreaching. We fight against governmental abuse. We don't choose our clients. We don't look at a client and say, well, you're gay, you're Black, you're white, you're, I don't know, whatever your sex or sexual orientation is. Same goes with politics, right? Drew is about the process. He's the most liberal person. He has tweeted against Trump with respect to Kaepernick, with respect to abortion. But politics don't count, right? For a true believer, for a true criminal defense attorney. We're here to hold the government accountable. And that's exactly what Drew's doing by saying, look, the statute's vague. You're overreaching by using the statute for a criminal charge versus what it's meant to be, which is in the civil context. And by the way, this DA has recused herself because of a conflict with a particular witness, but she has not recused herself from the entire case, which is very odd. When you have a conflict, it's not, you recuse yourself from the entire case, it's all or nothing. You don't just recuse yourself with respect to one aspect or one witness or co-conspirator or whatnot. So he's attacking that too. So he's listed this, it's a very well-written motion, and he's covered all these grounds, which are procedural. He's not going into the evidence, the phone call, and what was said, and it's not like that. It's more like the equivalent to a motion to suppress. It's a motion to quash the findings of this grand jury. So I'm not sure where that's going, because I tend to see now that there are problems in that case too. And if he's indicted, they have a very strong appellate fight, based on what Drew has put in the record by way of this motion.
You see, Nick, if we ever make it big time, now we know who to call from a criminal defense attorney perspective, because we would be lost without this. We've had other prosecutors and other.
Dude, how big are we going to get?
Well,
we can afford her.
I don't know.
Guys, but truthfully, aren't we more interesting? We're the ones. We're the ones that bring the heat, right? We're the ones
that's true.
Up with the really creative avenues for justice.
Right.
Prosecutors, so like my friends who are prosecutors won't argue with this. It's an easy job. It's an easy job. You come from the position of power, and even if your case sucks, you really start in a very uneven playing field, And I think that it's more fun and it's more creative and colorful to be a defense attorney, but at least it is for me. You know what Drew said, which I love, I actually quoted it on my Twitter. He said, that's the job, that's our job, that's the job we do, that's the game. Now, if you don't like it, go close real estate deals or something like that. And I thought, it's so true. A real defense attorney really cannot choose the client based on political beliefs or affiliations or anything. It's because our real job is to uphold the Constitution, and that should apply to everybody.
Yeah. It's why I reached out to you and had you on the program. Sara Azari is a white collar criminal defense attorney. Go get her book. She doesn't want to plug it. I'm going to plug it for her. Unprecedented, a simple guide to the crimes of the Trump campaign and presidency. It's available now wherever books are sold. Sara, thank you so much for hopping on the podcast. You're welcome back anytime to educate our audience.
Nice to be with you and meet you.
Yeah, likewise. Thank you so much, Sara.
Take care.
Hey, thanks for watching the Can We Please Talk podcast. Whatever clip you just watched, we hope you enjoyed it. And we hope you stick around for some more. Subscribe to the channel. My partner's over here smashing the button. Come on, do him a favor. So hit subscribe.